Ciao a tutti. This is Prof Jo at Prof Jo Explains. Remember the children. Kouri Richins is gone. Kouri is a convicted murderer, and there are 3 boys who are now 12, 10, and I believe 8. What will be their fate? We are really privileged to have tonight a experienced trial attorney, a former judge, a court TV host, someone who has been an advocate for children for entire career. She was the child advocate for the state of Georgia for 3 years. So she will be able to really share with us her expertise and perspective with regard to the boys and their situation and what one might expect from them or for them going forward. And then also her perspective as a litigator and a judge as to some of the things we saw during the trial. So I'm not going to waste any more time. I want to bring her right on. And so we will have now with us Judge Amber Wilkins. So welcome. Well, Ashley Willcott, sorry. Ashley
No, that's
Willcott.
all right. Thank you, Jo, for having me. I'm thrilled and honored to be on with you.
Well, thank you so much. We are thrilled and honored to have you here. So let me start right in. The children were 9, 7, and 5, I believe, when their father was killed. From all reports, he was a great involved dad. Their mother has been in jail for about 1.5 years or 2 years now. And now she's looking at probably a life sentence with very little possibility of ever being out. What needs to be done for those boys?
So much. So let's start with this. Don't forget that in that interim, after they lost their father to a horrible, horrible death, right? There was a book, Are You With Me, written by Kouri Richins, the grief book about how children can get through grief. Okay, so she's doing that because arguably, understandably, her children are grieving the loss of their father. And you think, what a great mother. What a great way for a mother to help her children through this. There it is. Are you with me? Only to find out now that she's been convicted that she was doing that all the while having been the one that killed their father. I would call that, let's back up a little and then we'll get to current, emotional abuse.
And let me just interject. At trial, it came out that she hired a ghostwriter to write the book.
Yeah, you're right. Absolutely. Now, in and of itself, I think a lot of people hire ghostwriters, but it adds one more layer of deception to someone who was accused of planning this horrible murder of her husband, Eric. So great point. And think about, she's hiring a ghostwriter. She's taking care of her sons. Everybody believes, well, not everybody, maybe not some family members, but people believe that she's a grieving mother. She's promoting this book. She's going out. Why? Money, 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 money. But all of this to say that now looking back, I can't even fathom what these 3 young boys were going through and the fact that a mother would have put them through this. And so even the time before she was in jail, what emotional abuse did they suffer? And that's going to be with them forever because they're going to know as they get older exactly what their mother did to their father. Then she goes to jail. And a lot of people ask me, Jo, what happens to kids when one parent's dead and the other goes to jail? Well, hopefully, as in a case like this, there's family that's appropriate, that can safely care for the children and love the children. Well, you saw during the trial, Jo, and I don't know your thoughts on it, but lots of family members of Eric were there, right? And you saw them there. Now, you also saw Kouri's, I believe it was her sister that we could see sitting behind her. I know, and maybe I can't recall for sure. I know his sister was there, and I cannot recall if her sister ever came to court or not.
Both his sisters were there and his father. Her mother was there.
That's right. Thank you.
And I don't know. I can't tell you about his sister because I don't know what his sisters look like.
Yeah. So and so there they are, and they're watching this unfold. So the good news is, in a case like this, yes, they've lost their father and their mother, but they're with family, which is ideally the way you want it to work if children lose both of their parents. Had they not had family that was suitable, they would have ended up in the state's custody. They would have ended up in foster care. So This is a good case, if there is such a thing in a horrible murder case, that they are at least with family during this entire time that she's been in jail, and now while she serves the rest of her life in jail.
What would you advise his sisters? One of them has custody of the boys, to say to the boys about the circumstances of the death and the mother being in jail.
What a
I mean,
great
if I were in your
question.
situation, I would want advice about how to handle it in the best interests of the boys, not for me, looking at someone who killed my brother, but for them.
Yeah, you just said the key words, what's in their best interest. And as a former judge, when I was on the bench, I'm going to tell you something. I relied on the experts because they're the ones that know. So if it were me, or advice I would give would be love them, be there for them, but consult with experts that you trust that can help them with counseling, can help them with therapy, can help you figure out, what do you say? I'll tell you this. The one thing I'm going to say is I have worked with a lot of youth who have grown up in foster care in really horrible circumstances of their home life, right? Abuse, neglect, sexual abuse, drugs, all these terrible things. And the one consistent thing they say to me as they age out and become an adult is the frustration is the entire process ultimately was about me. And yet I didn't feel like I was a part of it. And people didn't want to tell me, oh, your mom did these terrible things, or, oh, your dad was murdered. And they said, the truth of the matter is we knew it. We lived it. If we lived it, why couldn't people tell us or talk to us about it? So I will say at the end of the day, how you do it is beyond my expertise. But the fact that there has to be some honesty and transparency, because Joe, you know as well as I do, even at their young ages now, they can see everything on social media. They can see everything, every detail on social media.
Plus, I know from being around lots of children over lots of years that they see and hear much more than some adults give them credit for. I mean, they're pretty
100%.
aware. Yeah, they're pretty aware.
Yeah.
So I'm sure that these sisters bear, if not hatred, certainly no friendly feelings towards Kouri. And so if they're honest with the boys, they can't hide those feelings. But is that the best thing for the boys, to hear the sisters say, we despise her?
You know, I
mean,
think every parent faces that, Joe. Like, think about it. And all those kids you've had experiences with, have you had to temper your emotions about a circumstance?
of course.
Absolutely. Of
Of course.
course, right?
Yeah.
So it's no different for them, even though it's another level of tragedy that they've had to go through at the hands of his wife, Eric's wife, who murdered him. It still means that they have to temper some of the anger and grief, and I can't even imagine the extent of their emotions that are all completely valid as a victim, but they have to be able to temper and present that in a way that's healthy in the best interest of the children.
Of the boys, yeah.
Now, how you
All
do
right.
that, I don't know. Like, I can't even imagine, right? Like, again, I'd have to go to the experts to help me as well as the kids.
Mm-hmm. In your experience, do children work this out? I mean, we see a lot of or I do in the chats, about, I don't know that they're ever going to get past it. And that's a pretty sort of sober prediction for these children. What are their prospects?
Sure. I don't think anyone gets past a murder like this. A murder, the death of a loved one, even if it's an accident, a car accident, nobody gets past it in my mind. What does happen is justice at the hands of our criminal system. And in this case, I would argue the fact she's been convicted of all charges, including the aggravated murder, and the fact she will not get out of jail anytime soon, in my opinion, knowing that we're awaiting sentencing, I think she'll be there for life. That is a type of justice. Now, it doesn't make it go away, and the children may never get past it, but it is a natural, positive next step in the story as it moves forward. Now, getting past it, I think, means different things to different people. And I have talked to people who have been victims of these crimes. Again, on the bench, you saw victim impact statements all the time, and it was heartbreaking. But so many of them would say, I'm not going to become the person that this act is, meaning, yeah, it's horrible, but it doesn't define me. I'm not going to be a horrible person. It doesn't mean that statistically now I'm going to go commit crime in revenge because of what's happened to me. And so children can be, they're resilient. Gosh, Joe, they're so much more resilient than adults, right? And so with the right tools, with the right support, with the right love, that I have no doubt they have the love of his family, with all of that in place, they have an excellent opportunity to never get past it, but to learn how to live with it in the healthiest way possible.
That's a great way to put it. Should they see her? What if they don't want to see her? What do you project, if you can, the relationship with her?
This is why they call you Prof Jo, because you've got all the great insight and questions.
I mean, the questions, not the insights.
Oh my gosh, you do, because a lot of this, in a good way, is based on experience, and that you're looking at the best interest of children, right? That you think of that first, versus someone like a Kouri Richins who didn't give a crap about best interest of her own children, which is horrific. But the reality is, 30 years ago, when I first started practicing child welfare, there was a belief nationwide and a practice nationwide that children should never visit their parents in jail. So that if a parent was in jail, even for a crime that wasn't necessarily domestic violence, murder, egregious, but might be fraud or check writing, right? That the belief was, no matter what they were in jail for, that it would be bad for a child to go to jail, to have that experience, to see their parent. So it used to be, it really didn't happen. Judges didn't want to order it. People didn't want to honor it. They just didn't really support it. But now that's come a little full circle. And there's a belief, as we learn about trauma-informed care, which is now important. And it's always been important, but it had never been identified, recognized, or practiced. So as we look at trauma-informed care, the reality is you need to do what's best for the child. And it may be through therapy, through working with the loving family, that the child gets to a point where they say, I need to see mom. I need to look her in the eye. I need that for me. One of the other children, given they're 3, as you mentioned, might say, I never want to see her again. And I can process this, and I can work on my feelings, and I can have a loving, supporting family, but I don't want to see her. So I think the important thing is, not only should experts and family help make that decision, but the children's voice needs to be heard in deciding, should they ever see her again? I know if I were family, I'd say, oh, absolutely not. But maybe that's not in their best interest.
So can Kouri file a petition with the court for reverse visitation, for the children to visit her and argue that she's got parental rights and it's in the best interest of the children? And will the children have an advocate appointed for them? And can the family members, the custodial, or at least the parent who has, I don't know if you'd say full custody, but at least in the interim custody,
she has full legal custody.
Yeah.
Right. So every state does things a little differently. And I don't practice in Utah, so I can't say specifically, but in general, in our child welfare system, again, you just hit the nail on the head. She has her parental rights. She is the mother of the children. Unless and until a court of law terminates her rights, she has every right to see her children, to know how they're doing, to have a say in who they're living with. And so imagine, if you will, when a parent is in jail and convicted of murder of the other parent, the spouse, like Kouri has been. And imagine if the parent says, no, I want my mom to have the kids. And this has happened in cases. And so then perhaps the maternal grandmother gets the kids. A maternal grandmother may blame the victim and the victim's family and say, you never get to see these kids. And then it becomes a horrible, messy custody battle, often without clear lines under the law, because courts are responsible for looking at the best interest of the child in any custody issue. And so that's a subjective task. Guardian ad litems are appointed. So let's say something is filed by Kouri Richins, or even maybe something's filed by one of the relatives. They have custody at this point. I don't know why they would file something, but let's say, for instance, Kouri Richins is writing letters to the kids or calling every day from jail. I'm not saying she is. I'm saying a what if. And maybe the relative says that's enough. This is traumatic. The kids, they don't need to hear this phone ringing. And who is it? Who is it? And we have to deal with the fact it's the mother. So they could theoretically file something. But in any of those cases, regardless of who files, you're right, it goes to court. A judge has to make a decision based on the evidence, and a guardian ad litem will be appointed to represent to the court based on an investigation what's in the best interest of the children. They often, again, look to the therapist, look to the experts to figure out what's best. But all of that to say, theoretically, these children could get moved from Eric, the victim's family, to a family member of Kouri. And a lot of people, I follow this on social media because it's my passion. A lot of people say that's not right. That's unfair. That can't happen. The only way it can't happen is if someone files to terminate her parental rights, for instance, the child welfare agency in the state. And I don't know.
In your experience, what are the chances that if a family member, let's say Eric's sister, files for termination of Kouri's parental rights, how often do the courts actually do that when you've got a parent who's been convicted of murder and is likely going to be incarcerated the rest of her life?
Sure. So every state's laws are a little bit different, but let me speak specifically to Georgia, where I am, because years ago, I represented our child welfare agency, and I was involved in cases as the trial attorney like that. And in Georgia, for instance, a proper ground of TPR is termination of parental rights is if a parent has committed an egregious offense, and that's usually one of the 7 deadly sins like murder or manslaughter, against either the spouse, the parent of the children, or a sibling of the children. And so in Georgia, I can tell you that under the law, if the court determines it's also in the best interest of the children, that TPR could be won based on the evidence that she's now convicted and in jail for the murder of their father, her spouse.
Okay. Well, your expertise in this area, I know they're going to be, I'm trying to look at the chat as I go. It's going to be very much appreciated, because the kind of questions I'm asking you are the ones I see in the chat all the time. And I don't do family law. And so I can give an educated guess about it, but it's much better to hear from someone who's actually in the trenches and had done it for many years and has really deep experience. So I know everyone here is grateful. Now, here's a question that's come up. Is it true? You may know this. I think I know the answer to this. Is it true Kouri took out life insurance for the kids? And if true, what do you think?
So I'll let you answer as well. I understand that's absolutely true. So I'm going to weigh in with you first.
Yeah. Yes, it is true. And she, as I understand it, took out, I don't know what the money amount is on the policies. I've never seen that, but she apparently took out more than 3. And as I understand it, she took out the policies during the time in which she was getting herself deeper and deeper into debt. And so I don't think it's so difficult for people to worry and draw a line from her general behavior and using money she didn't have to take out life insurance policies on the children when there doesn't appear to be any particular, pressing need to do it, and what might have been in her mind at the time. But it's all conjecture, clearly.
It is all conjecture, but I would suggest that it's motive, right? And so when you look at the fact she was millions of dollars in debt, she stood to inherit approximately $4 million from Eric's estate. And the only reason, in my mind, for a person like this, who I believe absolutely planned this murder, this aggravated murder, and then proceeded to use it to her advantage financially by writing this book, How to These Life Insurance Policies. I can think of no other reason, Joe, why she would take life insurance policies and those amounts on her own children, unless she had in mind doing something to those children to make sure that she could collect on their life insurance policy.
Yeah.
To me, it's a no-brainer. I can't imagine any other reason why she would do it.
It's a horrible thought, though, isn't it?
It
And
is. It is.
do you think it would be appropriate for, let's say, Eric's family, were there to be a custody issue, to make that argument to the court?
You can, so as you well know, with evidence, and the judge has to always determine, number one, is it relevant? Number two, is it admissible under the rules of evidence? And so, for instance, it has to be more probative than it is prejudicial, but it's evidence of motive. And so, motive in terms of the relationship with her children and what she really thought of her children and what's best for her children. I would argue, listen, she's in jail the rest of her life. If she's callous enough to have taken out insurance policies on the children, multiple insurance policies, after she did it to her husband to kill him to collect the money, and she's been convicted of that, she's probably not the kind of person that needs to have a relationship with her children, because she's manipulative. She pre-plans everything she wants to her advantage. And I don't think she at all gives a care about these children. So I think that that is good evidence to help show a court, this is a reason why she should never be allowed to have rights to her children. They should be terminated.
Mm-hmm. Well, I can speak for the chat that you've made everybody feel much more comfortable and happy.
Now, I'm not, here's the thing I have to caution though, and I was one, so I say this, you never know what a judge is going to do. That's always the problem. And so here I say theoretically, and and here's the other thing I'm going to throw in there. Experts who are well qualified and have the expertise are great, but it doesn't mean you're always going to agree with them. So it could be someone working with the children might say, listen, judge, it's really not in the children's best interest because they still have to process this. They still have to process their grief. And we need the opportunity as they get older to be able to suggest to them, they talk to the mother, have a relationship with, and we don't want the rights to be terminated. Now, I'm not saying that would happen, but it could. It absolutely could.
I still think you've made the chat feel much better because you have at least given a context and some solace to them that that result isn't necessarily going to happen, and maybe it isn't the most likely result, although you can't predict the future with complete certainty. So I'm going to thank you for them.
Thank you.
Since I feel the same way, I think Eric's family should keep the children and raise the children. I'm glad to hear that it sounds as though the family law courts and the children's courts seem to veer in the same direction. Well, I wanted to get that out because your expertise is so clear in this area, and I haven't heard anybody else talk about it. But I also want to move on to the trial itself. And I will say to you that I thought some of the things that happened at the trial were really, let me say, unusual. And I will give you two, and I'd like to hear your perspective, both as a trial lawyer and a judge. I thought the continuous interjection of comments by the defense lawyers as they were asking questions was incredible to me. And the fact that it appeared that the prosecutor didn't object or say something at sidebar, and that the judge didn't intervene at some point and cut it out, was also amazing to me. And some of the comments, okay, you can say, right, okay, I thought so. But some of them, I remember around the first or second day, one of the defense lawyers was pushing one of the witnesses to say something she wanted. And when he did, she said, that's right, that's what I need, or something equivalent to it, which I was just really surprised at. So I would like your perspective, both your experience as to whether you've seen that happen, and your perspective on what the judge should have done.
So it drove me crazy. I noted it also, and it is bad form and it's not proper and it shouldn't be allowed. But keep in mind, there are two kinds of judges. Most at this level of handling a high profile criminal case where they've been on the bench, and I thought this judge did an excellent job.
I did too. I did too.
And many judges take the position, I can't say anything if nobody objects. And it's true. The prosecution wasn't objecting, but it didn't surprise me because it made the defense look bad. I felt, that's my opinion, it was a bad look for the defense and its strategy. Does the prosecution want to object if they think it's hurting the defense? No. So it could have been a strategy decision.
Yeah, that's what I guessed, because he certainly could have gone sidebar. He didn't have to do it in front of the jury to raise it. And since the judge didn't do anything, it certainly seemed to me that the prosecutor wasn't doing anything. And so then you ask, why wouldn't he? But I agree with you as an observer. It was driving me crazy.
And I think, I was a very active judge. And so I was one that I'll tell you a quick story, and it was embarrassing, but I was a trial attorney for years before I was on the bench. And the second or third time I heard a case, this attorney kept doing something that was so flagrant. And I all of a sudden burst out objection. And I was so embarrassed. And I had to put on the record that I had done it, that it was an accident, but it was because it was so blatant and nobody was objecting. And so I would very much in a case like this have called them up at some point and said, listen, I know there's no objection. Stop with your comments. It's not appropriate. You need to ask the questions. I'm going to caution you one more time, but you've got to stop. So I agree with you. And I probably would have handled it that way. But let me say this too, Joe, there were a lot of sidebars. For all we know, the judge could have told them that because there were a lot of sidebars.
But it didn't seem to reform the behavior.
No,
So,
but it often doesn't. People have habits and they keep those habits regardless of what a judge says.
What about the comments by Lewis during the closing? I was a mother and I was widowed at the same age as Kouri, and it's, interjecting a personal experience in the middle of a closing.
So
would that be
it's a style, it's a strategy. There was no objection again, so they were allowed to do it. Every state, and I again don't know specific to Utah, gives different parameters of what you can and can't do. Now, one thing you can't do anywhere is what's called the golden rule. You cannot ask a jury to put themselves in the shoes of the victim or the families, right? You can't do that. That automatically should be objected to and will be sustained. And it's a problem if you do that. In fact, it could cause a mistrial. But in terms of injecting your own personal experiences, is it good form? Maybe not. Is it good practice? Probably not. Is it a strategy? Absolutely. I probably would have objected to say, Your Honor, this has nothing to do with the facts of this case. Keeping in mind that also training wise, lawyers are trained as trial attorneys that you really should not object during an opening or a closing unless it's so egregious that you need to make a record. Now, I think it's so egregious, I would have made a record, but that's just my personal style.
Well, I don't have this obviously I don't have the same amount of trial experience you have, but we have the same instincts about this. I will say that. And
it takes I have one more thing to say about it, Joe. The other thing it does is it takes the view away from the case. And whether you're trying to get a prosecution out of this or whether you're defending the alleged criminal, either way, the last thing you want to do is draw the jury's attention away from this case and onto yourself.
Yeah. What did you think? I hate to keep piling on the defense because I thought substantively they did a good job. They knew what they needed to do. I mean, whether I agree about how they decided what they wanted to do, they had a clear picture of what they wanted to do. And they pushed. And although sometimes they drove me crazy with the way they pushed and kept repeating arguments, they were tenacious and I admired them for it. And so I thought in terms of the defense itself, they did a good job, but the style and some of the fiddling around and, you're going to be asking questions and you don't have the document ready to go was just, I assume it bothered you too. I mean, I didn't
Oh,
understand it. I didn't understand it.
listen, again, I've seen lots of trials, whether we're covering it on TV or whether it's been in my courtroom. And that's so common. So many lawyers don't have the staff to do it for them well, or don't know how to do it, that it's very common. There's bumbling around with the electronics or the aids or the computer or whatever it is. So I don't think it's that unusual, but it does drive me crazy. If you're going into court, you find a way to be prepared so you're not wasting everybody's time, the judge and the jury included. The other thing I have to say about that is, style is, again, something that makes a difference. And I always would remind viewers on court TV that you don't know what the community is like where the case is tried unless you live there. And so the attorneys trying the case may have similar mannerisms or demeanors as the community, and they may know how to best reach them and speak to them. Now, some of the things you've mentioned, I would agree they should, it's not best trial practice, but they may have had a personality and a strategy knowing what the community was like where they were trying their case.
That's a really good point. Thank you. I also was, let me say it this way. If I were doing a trial and I was making an argument and the judge gave me a case or said, here's a case that goes against you, I would be embarrassed. I would really be embarrassed because I feel maybe this is the law professor coming out, very strongly that if I'm going to make a legal argument, I damn well should know what the law is. Now, I may want to argue that the law doesn't say what the law seems to say, or as they did at one point, the reasonable doubt instruction is under review and you shouldn't give it because it may be reversed by the Supreme Court. But not to have the law and be able to argue what's there, to say you couldn't find it, and then the judge says, well, I have a case. I think I would really be embarrassed.
Yes, you never want the judge to one up you with that. And I think, again, is someone as a lawyer in court going to be unprepared or not ready or not have a case? Sure, but it's how you handle it. Instead of saying, oh, I can't find it, I don't know it, I don't have it. If you have to, say, Your Honor, could we have a 5-minute break? Could we have a 10-minute break? And you call on your resources to figure it out, because it does look bad if the judge is educating you about your case.
Yeah, and he did a lot of that.
He did. He was great, but you did. I agree.
He was. Okay, here's a question from the chat. Donald Adelson and Kouri seemed so shocked that they were found guilty. Do you believe that the defense attorneys gave them false hope by encouraging them not to lose hope?
Different defense attorneys have different personalities, and I am sure that they probably tell them not to lose hope and advise them of the chances of succeeding at trial, which may not be good. But you have to realize these two individuals are not your normal, rational, average person. They are not ones who...
That's such a kind way of putting it.
Right? They're crazy, bat crazy. I mean, and so you can't attribute, I think, this is my opinion, normal reactions, emotions, or keeping hope to individuals like this. I don't think either of them think they did anything wrong. I truly believe they do not think they did anything wrong. So why would they need hope? Of course they're going to get off. They didn't do anything wrong.
Yeah, I agree with you. I do. Now, I do give them grace in something that also bothered me, and that is the number of times one or the other of the defense lawyers misstated the testimony. Yeah. I give them grace on that, at least to some extent, because you've got all those, the documents and the depositions and the pretrial hearings. And I think you can really lose track of what actually was said on the stand when the witness was on the stand.
That's normal. We make mistakes. I agree, give grace. But I'm going to tell you this, the difference I've seen between an excellent trial attorney and a mediocre is the support team at the table. Because if they have a good team, they can have it at their fingertips and their team can slide it to them and they can read it off. But if you don't have support to help you, whether it's other attorneys, paralegals, secretary, assistants, whatever it is, you cannot possibly keep everything straight in your mind, especially on a trial of this caliber.
I agree. Now, they did have 3 defense lawyers, and there was at least one, I don't know whether he was a paralegal or he was their investigator, but there was someone sitting behind them who would assist. Uh,
Hmm.
and over at of course, the prosecutor had more resources, that's clear. But I did think, I mean, neither of them was up there alone. They did have, looked like some fair amount of help. But
I agree,
anyway.
but then you have to ask, and I don't know, because I do think I agree with you. I think the defense did a really great job with what they had, and the style was something that people may not like. But I also have to say it's hard to have 3 attorneys. We are, and I will admit it, we are accustomed to doing things our way. And if we're a trial attorney, we're accustomed to being our kind of trial attorney. So then if you have 3 and you have to split up responsibilities, and does it get more chaotic and therefore messy? Maybe that's what we saw.
That's fair. And I also think it's possible that with 3, no matter how coordinated you are, no matter how many minutes you have, I can't know the evidence for which you're responsible as well as I would know it if I was doing it. I mean, it's
100%.
inevitable. It's inevitable. So, well, what did you think about the strategy of resting and not putting on any defense?
So, for those of viewers who watched this trial, I always watch the defendant because the jury's watching the defendant. And she was so unemotional, nonplussed. And that's not to say that's how she was feeling, but the perception in my mind was she's not likable. And watching a defendant throughout a trial, and she never changed demeanor. She got a little animated when she was aggravated with some of the, what she would argue were stories, probably really the truth coming out of some of the
And rolled
witnesses
her eyes
against
at
her.
times.
Yes, rolled her eyes at times and would kind of get like this with her attorneys. But generally, I don't think she looked very likable. And the person who knows best as to whether or not a defendant has a good story that they have to tell on the stand and whether or not they can be likable and credible is the defense attorney. So the defense attorney may have said, you can't tell a story that this jury is going to buy. On the other hand, the defense attorney could have said, listen, I mean, they wouldn't say this, but I'm also thinking if she's been able to manipulate everything the way she has up until this point, she may have been able to tell a good story on the stand. She may have been able to manipulate the jury. She may have said, even though you're telling me to testify, I'm not going to. We're never going to know if it's always her decision, but we
Right.
don't know what the defense counsel might have advised her. I would not have put her on the stand because she didn't look likable to me at all.
Yeah, she didn't look likable to me either. And I didn't seem to me that she would have been able to stand up to cross-examination. There were so many places in the evidence where she would have to explain something, and I have no idea how she was going to explain it.
Good
And
point. I
so,
absolutely agree with you. And there were too many holes into. Can you imagine? Think, Joe, if you got to do that cross-examination as a professor, you would have had pages and pages and pages and pages of things you would have asked her.
and I would have salivated. I'm sure he was disappointed that he didn't get the chance to do it. Yes, absolutely. So, what did you think of the state's closing?
It didn't do a lot for me.
Really?
I
Okay.
felt like it was a little, now viewers don't, most of the viewers didn't think this. I felt like it was a little patronizing, but I don't know why I felt that way. I'm just telling you my emotion, but they put it
Mhm.
all together in a way that I think obviously convinced the jury there's no other reasonable explanation. She had to have done that.
Yeah. I actually liked the prosecutor a lot. His style, which was not warm and fuzzy, resonated with me. It didn't bother me at all. And I found him at times, I think what you would say is patronizing. I found him really amusing.
And
Uh,
you know what, doesn't that speak volumes as to the power of a good attorney? Because the jury pays attention to that. And obviously they found it like you did, most likely, because they did convict her in just 3 hours, which is exceedingly quick for such a long trial.
right, right, right. What did you think of the rebuttal? I'll tell you what I thought. I thought he was exceptionally well prepared in that rebuttal. He not only did he have, their documents and the video clips, but he had them in order. He was just ready, clearly ready clearly had a very good idea what the defense closing was going to be, and he just was ready for it. And I was really quite taken with him in the
I thought
rebuttal.
he nailed the rebuttal because it did exactly what he needed to. Not only did he get up there and make his points, but he did it, to your point, with video, with aids, with documents to be clear. I'm not making up a story that I want you to believe. I'm telling you the truth based on the evidence.
Yeah. Yeah. So you said you liked the judge. What about the judge did you like?
Oh boy, he didn't really take flack, and he talked a lot and he said a lot, but he didn't put up with when there were objections. He would call him to the bench. He would enter a ruling. He would say sustained and move on. And that's what a good judge needs to do, because in applying the facts, the law to the facts, rather, you have to create a record so that if there's an appeal, it's appealable, it's a sustained, it's a overruled. And I felt like he was very effective in doing that. He also, to me, just didn't put up with anything. His tone let you know where he stood with things, in my opinion.
I agree. I also thought, I mean, there were people in the chat during the course of the trial that felt he let the defense go too long. And there were times when I thought he could have cut it off sooner, but I thought he gave them a real chance to make the argument. I thought he was pretty sincere about, let me really understand. And if you want to tell me again because you think I'm not getting it, go ahead. But then when he made a decision, he was like a rock. I mean, the decision was made. So I really liked him. I liked his sense of humor.
Yes.
He was amusing.
And smart. I thought he was smart, right? He just came across to me as a student of the law who wanted to do the right thing and had a reason for the decisions he made throughout. And I'll tell you this, there's a good reason in my mind to give the defense or the prosecution the floor for longer than maybe viewers think they should have. And I think that's because you want them to put it all out there. The last thing you want is to not have a good record. So again, if somebody appeals a particular finding you've made as a judge, I want it on the record, and I want what I say on the record, and I want to give them the opportunity to put it all out there, even if it's lengthy.
And I love the way he protected the record. I mean, yes. I loved his rulings. I mean, I'm imagining, because I've done appeals and I've looked at, I just love the way he just made it so easy for an appellate lawyer to go in and defend the decision had there been what happened, a guilty verdict. I just loved it. So I really enjoyed him a lot. I really thought he did a very, very good job at the trial. So what did you think was the strongest evidence against Kouri?
So I went back and forth. Again, the state presented, I think, 40 witnesses, maybe a few more than that. And so I think for me, when you have the woman who provided the drugs that were used to kill Eric, allegedly, that to me was some of the strongest evidence. Because without that evidence, you might say, well, maybe it was a gummy that was laced with fentanyl, because we hear about fentanyl getting into lots of drugs. Once you have the evidence of these were the drugs provided to Kouri, for me, that was the strongest piece.
So you didn't find her credibility questionable, given the the change in the story and the I can't remember, and I was the can't remember. So I thought to some extent I thought she was very believable. I agree with you, but I thought to some extent she allowed herself to be pushed by the defense in places where maybe she should have stood her ground. If she was a different witness, she might have put the stake in the ground and said that's not what happened.
Yeah, she was
so
mushy.
Yeah, that's a good description of her, mushy.
I definitely thought she was mushy, but at the end of the day, looking back at testimony as I was kind of evaluating, I felt like, you know what, even though she was mushy with all the other evidence as well, I felt like it was very credible and a reasonable explanation of exactly what happened.
Yeah. Did you think she was the strongest witness as a witness?
No. And I'm, Jo, go ahead, because I don't know what my answer would be for that.
strongest. I'll tell you which one I liked the best, and that was the forensic accountant, Carrington.
Yeah.
Partly
So
because I was
credible.
just, she was, but partly because I was so flabbergasted at the ability to keep on getting loans as you're getting deeper and deeper into debt. I mean, the story she told was so fascinating to me. And I kept thinking, it can't be that, that somebody can keep getting money as this is going on. But I thought she was just really amazing. So she was
And
my favorite.
she was, I thought, an excellent witness, very credible. The other part of that that's interesting to me is she was really testifying about motive, not one of the elements of the crime. I mean, there was the fraudulently claiming insurance benefits piece of it, but
Right.
a lot of that was the state's argument for motive. And it's fascinating to me. Sometimes we're guessing, why would they have killed a person? Boy, this case brought it to the forefront, very loud and clear. We're going to tell you exactly why she did it. It was all about the money, and that witness sealed that.
Yeah, she did. She did. What did you think of the private investigator?
I have to be honest. So, when we're covering these trials, we're in hair and makeup before we take the anchor desk. And so we don't hear all of the trial. And I got in there at a time when he was testifying. And I remember thinking, Joe, like, gosh, who is this guy? He's like a banker. Is it a financial person? And then I learned it was the PI. And I was surprised. I was like, that's not necessarily what I would have pictured.
Yeah. Yeah. You've frozen.
Oops.
You're back. Okay.
Okay, good,
Yeah,
good.
you're
No, I
back,
was
I
just
think.
saying he
Yeah.
wasn't what I would have pictured for a PI that was hired. But at the end of the day, I also I found that how smart of the family to get a PI and use a PI because it was good evidence.
Yeah, it was. And what do you think the most likely issues are going to be that the defense raises on appeal?
Do you know,
Have
I
you thought about
honestly,
that?
no, because I don't do appeals. I haven't done that in my practice. And so I'm not the expert as you are,
Mhm.
having done them. You always, not you, I always think ineffective assistance of counsel is going to be one of the things raised. And,
Mhm.
are the things that we've discussed that might have driven us crazy watching the defense really objectionable or grounds for appeal, or rather were those things that didn't affect the body of work that they did? Because I thought they did a yeoman's job. So
Yeah.
I'm trying to think. That's a really great question. And part of
Well,
the
I'll give
reason,
you one.
yeah, tell me.
Go ahead. I was just going to say, I have no doubt that they are going to raise on appeal the introduction of the financial testimony as being not relevant to anything in the trial, and if relevant, overridden by prejudice. So I do think that's going to be one issue. And I thought the judge did a really good job. Most of it he didn't allow in. It's going to be a different prosecution entirely. It's not like Murdoch, where it all went in great detail. But I think that will be one issue that they raise. We could talk forever, and I wish we could, but you've got a hard exit, and so I don't want to hold you up.
Oh
Thank you
my
so
gosh.
much for coming. I hope you'll come back and talk to us about this trial or another
Anytime.
anytime.
You're fantastic. And I appreciate your expertise and helping us shine a light truly on what it's really like for children who go through something
Yeah,
unimaginable like this.
great. So thank you so much.
Thank you. Take care.
Okay, right. Okay. Didn't see very many questions come up in the chat as we went, but I hope that some of the questions that have come up in the chat as we've watched these trials, uh, with regard to the boys and what's going to happen to the boys, and will Kouri keep custody of the boys, and can she control whether Eric's sister will retain custody of the boys, and all of that. I hope she gave you some really broad and deep understanding, certainly more than I could have offered, because that's not an area that I've taught or practiced in, and mine would be essentially giving you my best guess, which turned out to be pretty accurate, but it still would have been a guess. So it's so much better to hear from someone who's got the expertise. So question from Barb Murray Babs. What is the next trial about? I assume you mean the next trial of Kouri. She's got, 20, 24, 16. I counted them once and I don't remember, but a number of there are a number of charges related to some of the financial things that she did. 3 of them were part of this trial, but there's a host of other claims related to her financial activity that are the subject of another prosecution. Thank you, Vesper Martini. 26 counts. And that's the next trial. And I am certain, virtually certain, that there will be another trial, even though she's been convicted here, because you never know whether a conviction will be reversed on appeal. And so the state has to take the position, what if this is reversed on appeal? And if you wait on the financial crimes, the statute of limitations may run. And some of them are very serious crimes. So that's what the other trial will be about. Can I explain why the judge appointed an attorney for Lisa Darden? Well, now you've got me, because I thought he declined to appoint an attorney. So somebody help me. I can tell you what the argument was. The defense, that's Kouri's defense lawyers, argued that Lisa Darden faced some potential criminal exposure, criminal trial, criminal liability, and therefore she needed a lawyer to advise her as to if she was going to be taking the stand either for the state on subpoena or for the defense. But I thought the judge denied the request to have a lawyer appointed for her. So if anybody knows better than I, if the judge actually decided that she should have a lawyer appointed, put it, get it in the chat, because I don't remember it that way. So other questions? Let me see. Okay. And all right. So I want to talk a little about one of the other, some of the evidence that was a trial. I'm going to do another live on some of the evidence. Actually, here, let me do this, because I see a question here from Luginger, UK, 1839. Do I know the maximum sentence, and what do I think she will get? I actually looked it up yesterday when that question came up. I couldn't remember, so I looked it up last night. The maximum sentence in Utah for aggravated first-degree murder can be up to life without parole. I have it here somewhere if I can find it. It can be 25 years to life. And so that's the maximum for attempted aggravated murder, which was the February 14 attempt to kill Eric. The sentence is 1 level down from aggravated murder 1 in Utah, and that becomes a felony 1. I believe anywhere from a minimum of 5 years up to, I should have it here somewhere. But the aggravated murder itself is can go up to life without the possibility of parole. And I believe what will happen is the judge will sentence those 2 consecutively. That's my best guess, because they are really completely separate incidents. It's the attempted murder in February. Okay, so Scotchbaum said he did approve legal counsel. Oh, for Lisa Darden today. Oh, so I'm not current then. What I knew was before the trial. So why is she getting legal counsel? Let me think about that a little and go on with this question, which is, I think they would run consecutively because they're 2 entirely different incidents. The February attempt, the March killing. And then on the theft, I didn't look at what the financial crimes maximums were. So, but I did look at the aggravated murder count, and I would suspect that the judge would give a really heavy sentence. My guess is that he will give life without parole, but that's a guess. With regard to the attempted aggravated murder, I think the way it works in Utah is the judge can sentence 5 years to life, and then the parole board, after the 5-year minimum, because the 5-year to life means she could be let out after 5 years. Of course, she's serving the other sentence, so she's not going to be let out, but let out after 5 years, and how much more depends on what the parole board sets. Okay. A lot of states don't do parole anymore, so you get what you get. Okay, Lee, and Lee told me she pronounces it Lee, or he pronounces it Lee. Do I think the lawyer on the jury might have been the juror who asked for the factual statement as they went to deliberate? I have no idea. Maybe, but I think any juror who was paying attention and listening might have had the same question. I just thought it was a great question because it showed how on the ball they were. So I want to go through, I want to do a little tonight, and then I'm going to do a video on it, maybe a live, maybe a video, I'm not sure, on some of the evidence at the trial that helped convict Kouri. And some of it, the one that I want to do, because I didn't really talk about it much before, were the phone searches that law enforcement found on Kouri's second phone. That's the phone that they seized in April 2022, and that was more than a month after Eric had been killed. And these were the questions. Let me see if I can get them big enough for me. Luxury prisons for the rich in America, which I think is really kind of interesting, that she thinks they're luxury prisons. I don't know what she thinks luxury prisons are, and that she considers herself one of the rich in America with the level of debt she has. She, with regard to life insurance, asked how long does it take life insurance companies to pay out? Let's see. Then then she had some with regard to the death certificate. Is the medical examiner's report and autopsy report different? She should say are. Her grammar's bad. Can manner of death be changed on a death certificate? And that was, remember, the manner of death that was put on the death certificate by that ME who was about to retire was undetermined. And she said, I think on the stand, she was going to be out of the office soon, and it seemed to her that that was the most sensible thing to do. And then they did the second testing to see whether there was fentanyl in the stomach. But anyway, she asked this after the first, can the death certificate be changed? And since it was undetermined, it looked like she was worried that they were going to change that death certificate to, murder. Let's see, is circumstances unknown an accident? That's what was on the death certificate. It was due to circumstances unknown. If someone is poisoned, what does it go down on the death certificate? She had another question. I don't see it on here, but I know, which was, can you remotely delete text from a phone? Which really seemed to me, of all of them, maybe the most suggestive of cover up or consciousness of guilt, because the police at that point, law enforcement, had the phone, and if she thought there was something incriminating on the phone, the question was, could she remotely get at it? Now, notice these things are not, gee, I saw her put the poison in the Moscow Mule. These things are not a text to her mother saying, it's done, I put the poison in and he died. That's direct evidence. I saw it, I said it. None of these are direct evidence. They're circumstantial. They are evidence in that she wrote these texts, and they're not. How long does it take insurance companies to pay? It's not, I killed Eric, but it is evidence, circumstantial evidence that collected with other circumstantial evidence can build a case so that it becomes a case where there's a conviction beyond a reasonable doubt. And that's what was happening here. And some of the texts, I mean, they weren't the texts. I mean, what's his name? I can see him in front of me now, who sent the texts after his wife disappeared, such as, how do you get rid of a smell of a body, and how do you clean up blood and all those things? These texts were not nearly as suggestive of criminal conduct as his were. What is his name? I'm so bad with names. I can see him. It'll come back to me, or Amber will remind me, because she's really good with names. But they still are suggestive. Now, could you convict her on the basis of those texts? Absolutely not. Not in a million years. No jury would even come close to a conviction if that's all the evidence was. But in the context of all the other evidence, you build the case, and they are relevant. They do go to show motive or intent to kill, or cover up. So they're all Brian Walsh. Yes, thank you. Thank you, Raven Plume. That's who it was, Brian Walsh. I can see him vividly. So I did want to talk about those, because that's a piece of, building a circumstantial case. And it's all the pieces together that get you a conviction beyond reasonable doubt. So, okay, are there other questions about our guest tonight, who I thought was really good? And I'm so glad that she was able to talk to all of us about, the circumstances of the boys, and the kind of the likely consequence if Kouri were to try to get custody, and the likely way it would turn out, although obviously she can't predict and she can't say. I'm absolutely positive nobody could. Okay. TD3 Nation, how do I feel about the fact that her mother did not bat an eye or get misty-eyed at the thought of her daughter being locked in prison for life? I do accept what defense lawyers always say, and that is people grieve differently. People react to bad news differently. People may not be emotional. They have different ways of dealing with crisis. So I'm less inclined to look at the way somebody reacts and say that shows, something substantial in terms of what that person's attitude is. Now, it could be that she's just a very unresponsive person, not very emotional, not very, more self-involved. Clearly could be that. She also could be somebody who just doesn't show emotion. It's all inside, it's all internal. It doesn't come out. I mean, some of us at the drop of a hat cry. Others are pretty stoic in the face of really bad things. So that's a very, very long way of my saying, I don't know what it means. Okay, Shaker Maker 1980 is the prosecution closing presentation. They showed a photo and named the undercover detective again. I didn't see that. If that happened, that was a huge mistake, but I didn't see it. So, okay, here's another. Why bother with the other counts if she gets life? Because she can get reversed on the life sentence. That's what I talked about a moment ago. And if she's reversed, there's no guarantee that on a retrial she'll be convicted again. And so you've got to go forward on the other counts just to be sure. Plus, they're pretty serious charges. And so some prosecutors might feel that you should do that anyway. But the major reason is there could be a reversal on appeal, and you want to be sure that you've gotten the other convictions and sentences on them, particularly since there's statutes of limitations on the other crimes. So if you say, well, she might get reversed on appeal, it'll be 3 or 4 years, we can try then, the statute of limitations may have run and you can't try then. So that's why. Did we ever get to hear what the undercover guy said? Not see him, of course, but hear him. Well, there'll be a transcript. And if that's part, and I don't know whether in Utah, in some states, the entire transcript of the trial goes up with the appeal. In other jurisdictions, the defense identifies the parts of the transcript that are relevant to the issues that defense is going to raise on appeal, and the state will add other elements of other pieces of the transcript that are relevant to the state's response. The entire transcript doesn't go, isn't part of the appellate record. I don't know what Utah does, but the transcript is going to be a public record, so you can get hold of it. You may have to pay for it. Whereas if it's part of the record on appeal, you can get it when the appeal is docketed. Okay. Will Kouri be wearing her civil clothes for sentencing? The answer should be no, but I don't know whether she'll be in street clothes or she'll be in prison garb at that point. Okay. I don't see any other questions. Are there any more questions out there, or have we exhausted our questions? Let me see over here. I will look a little and see. I was at a Irish bar here in Sorrento, Italy, and some of them were wearing big Irish hats, and they had green beer. I had a green beer. I'm not a beer drinker, but I thought you had to do it. It was a lot of fun, but the Irish songs that they played were a Simon and Garfunkel song and a Johnny Cash song. They are not the Irish songs that you would hear at an Irish bar in the States, and I think I'm going to do a short on it. It was fun, and it was a nice evening. Okay, Lunging, I wish somebody would help me with how to say these names because I hate not getting them right. Luginger, UK. A funny one for you, do I think the prosecution redeemed themselves for not reading the text messages with the closing arguments? Yeah, I mean, he did use them there and did do a good job with them. I still think when you're putting texts up on the screen during the trial, somebody should read them. I just think it has more impact. And I guess I don't understand why he doesn't like it so much. But I thought he did a good job at trial. And so I didn't think he had anything to redeem himself from, even if he didn't put the text up. Do not go to Naples, especially at night. I'm going to Naples on Thursday, and I've been in Naples before. So I guess I'm not going to be able to take your advice. Well, we are going to see Nestor again in the Kirk trial, and you've heard me say I hope the judge in the Kirk trial is a pretty strong judge and very, very decisive, because otherwise that's going to be an interesting experience. That's my view, an interesting experience if the judge is not. Okay. Oh boy, oh boy. Oh boy, oh boy, 22. Thank you so much. Buy my own what? I don't know what I'm supposed to buy, but thank you very much. I appreciate the is it a super sticker? I don't know what these things are called. I apologize, but I do appreciate it. Okay. Lou Ginger, YouTube ignores the uppercase. Well, let's write letters to YouTube and complain. Okay. All right. Thank you for all you do. Thank you so much for the thank you. Let me see if there are any questions. You've got to put the question marks because this type on the screen is about 1/64th, of a point. Did I get a nap? No, I was working around all day and then I went to the bar. I had to go to class this morning, and then I had a couple of errands here. So no, Judge Ashley was a great guest. I thought so too. I really did think so too. Okay, I will wait another couple of minutes to see if there are any more questions. And if not, we're going to go off. If there's a trial that you know of that's coming up in the next, let's say, 6 weeks, that's being streamed, It isn't simply that it's coming in the next few weeks. It has to be something where somebody is streaming it, because otherwise it's not a trial that I can cover. Okay. Just Leo Wren, just a comment, buying insurance on your children is not always nefarious. Well, that's obviously true, clearly true. A lot of parents buy insurance on their children. A lot of them do term insurance so that, by the time a child is ready for college, that the insurance policy, can be used to pay for part of college. No, I don't think anybody ever suggested that it was always nefarious, simply that in this situation, when she seemed to be way in debt, that's when she chose to buy the policies that seemed a little suspicious. Okay. S. Somerville says, best from Canada and best to you in Canada. Okay. Well, I don't see any more questions, so we're going to end now. And I probably am going to do something tomorrow night at 10 Eastern time. Pretty sure. Not absolutely sure, but pretty sure. So, ciao a tutti. Thanks to my subscribers. Thanks to you to hit like. And if you didn't hit like tonight, why not? All it does is, just hit a little button. And share, which also helps. Any of my videos that are a week old, I think they have to be out of it. I'm not sure. Maybe after a week you can't do it. Please hit hype. And to my members, I really appreciate it. So, ciao, everybody.